Hi, and welcome those who have joined nice and early. I'm going to give us 5 minutes before we start.
Hi, everybody. Welcome. Just waiting for a few minutes for everyone to join us, and then we'll start probably a few minutes after 1. Everything is ready, but we'll just wait for just a few minutes longer, if you don't mind. Thank you. So people are still joining. I think we'll set the time as 13:05, 5 minutes after 1 to start. So if you need to make a cup of coffee, get yourselves ready, get your notes out or whatever, please do so. And then at 1:05 we'll open the meeting, and Louis will carry on with the presentation. Thanks.
While we're waiting, if there's any requests on specific topics for future seminars, you feel free to leave me a comment or send me an email. I still have a month or two open that I need to fill in and look for. So if there's any specific topics that you need covered, let me know and I'll see what I can do. All right, I think, Stan, let's get started, and then we'll let those who don't aren't here yet, they'll have to then catch up on the recording.
I agree. Okay, thanks very much. Thank you everybody for joining us. It's been a little chilly lately, so maybe the subject will warm you up. I see the topic is principles, practice, and challenges. For me, the main challenge is getting into the will. So once you've achieved that, all the rest will take care of itself. So It's my pleasure to introduce Louis van Vieren, expert in wills and estates, and looking forward to learning something today. And as I said, thanks for joining. If you haven't got notes, just let us know in the chat and we'll send them to you if you when you expect the certificates in a day or so, and we'll send them to you. And so, Louis, the floor is yours.
Thank you very much, Stan. I hope the sound is good. Ladies and gentlemen, we are going to work through quite a lot today. So I would suggest fastening your seatbelts. It is quite an extensive agenda. We're going to start with wills, look at capacity to make a will, formalities for execution. I'm going to work quite quickly through these because the knowledge around this is fairly basic. just ask the question, codicil or new will. The way out, if formalities have not been complied with, I'm going to look at two relatively new cases on Section 2, Sub 3 of the Wills Act. Then just looking at why we're still stuck in South Africa with paper-based wills, hard copy wills, which have to be signed. Revocation of a will, wills and divorce. There was an interesting case recently in the Supreme Court of Appeals. 3 years ago, in a similar webinar, I dealt with the High Court case in that matter, and in the meantime, earlier this year, the Supreme Court of Appeals ruled on the same matter. Then death, disqualification, or renunciation. What happens if you die before you can inherit, or you are disqualified, or you renounce your benefit? What happens then? Interpretation of the provisions in a will, disqualification of heirs, conditional bequest and modus, and the difference between those. Then I'm going to look at what is called nude prohibitions, which I have recently again seen in a will, and the problems that can create. Freedom of testation and its limits. The pitfalls and practical considerations when or often encountered in will drafting. And then lastly, what happens if you die without a will? A very brief look at the intestate succession rules and one or two things that happened in the last couple of years on that score. Then in the estates part of the presentation, we're going to look at who can be executors, the reporting of an estate, letters of executorship, finding and taking control of assets, advertising, claims for and against the estate, the liquidation and distribution account, advertising the liquidation and distribution account, objections against the account, taking fees and other administration costs, income tax, including CGT, very briefly, just the main principles there, the distribution of the estate, and then lastly, a quick look at estate duty. And just wrapping up then with, if we have time at the end, questions. There is some 60 slides, so hence my call on you to fasten your seatbelts. Okay, so let's jump in straight away with capacity to make a will. Now, the Wills Act in Section 4 requires you to be at least 16 years old, but there is no maximum age. So in some of the European legal systems, there is a maximum age where the law starts to assume that you are no longer, you don't have the capacity any longer to make a valid will. That does not apply in South Africa, so there is no maximum age. And in our law, the Act actually presumes, the Wills Act presumes that anybody who makes a will was in sound and sober senses when the person did so, and anyone who alleges otherwise must prove it. So if you want to attack a will on the basis that the testator was not in sound and sober senses at the time of executing the will, you will have to adduce evidence to prove on a balance of probabilities that the person was not in sound and sober senses. There's no maximum age. As I said, there's the Supreme Court of Appeals case in Levine versus Levine in 2011, where the testatrix was 107 years old when she executed her last will, and the will was then attacked by some of the family members on the basis that she was no longer in sound and sober senses, could not anymore or any longer take sensible decisions about her affairs. The Supreme Court of Appeals eventually ruled that on the evidence there is nothing to show on a balance of probabilities that she was not capable of making the will. When the possibility of doubt exists, it is always good to ensure that evidence is available of the state of mind of the testator. In Barnard versus the Master and others, 2015 Pretoria High Court matter, the testatrix did suffer from some psychological problems. Before she executed the will, she went to see a psychologist voluntarily, and the psychologist eventually testified in the civil matter, in the civil trial, that she was in sound and sober senses, was coherent, was thinking and talking logically, and that there was no reason to doubt that she was in sound and sober senses. In that matter, the court then found that the onus of proof to prove that she was not met, and the will stood. And in that case, the court actually condoned that will under Section 2, Sub 3 of the Wills Act, because the formalities for signing the will was not strictly adhered to. One of the witnesses was not present when the testatrix and one of the witnesses signed the will. The following persons cannot make a valid will. Obviously, any person under 16 years of age, persons under curatorship, and persons not under curatorship, but with clear impairment of their ability to make sensible decision. If we look at the formalities, the testator must sign each page, and we're going to look at a case in due course in a couple of minutes where the testator only signed the second page and what happened in that matter. But the testator is required by Section 2(1)(a) of the Wills Act to sign each page. The last page is to be signed where the text stops. And there's the 1983 Eastern Cape matter of Kidwell versus the Master, and another where the signatures were on the last page were about 15 centimeters below the end of the text on that last page, and the court found that does not comply with the requirement in the Wills Act that the document must be signed at the end thereof. The testator must sign in the presence of two competent witnesses or acknowledge his signature to them while they are both present. So the testator can sign while nobody else is present, and the witnesses can sign later in the presence of the testator and in each other's presence, and then the testator can at that opportunity can then identify and acknowledge the signature on the document as being his or hers in the presence of the two witnesses who are present simultaneously. Witnesses do not have to sign each page. They are only required to sign at the end, but as a matter of good practice, I've always required witnesses to sign all pages. That just prevents a situation where a dispute could arise about whether the testator signed a particular page while in the presence of the two witnesses or acknowledged it to them. So a competent witness, Section 1 of the Wills Act says a competent witness is a person of the age of 14 years or over who at the time he witnesses a will is not incompetent to give evidence in a court of law. The reason why it's 14 comes from our common law, where persons below 7 years of age was generally regarded as totally incompetent to perform any legal act. Persons between 7 and 14 years there was a presumption that they were incompetent, which could be overturned by evidence, and persons over 14 years were presumed to understand the nature of what they were doing. So if we then carry on with the formalities, signing also includes the making of initials. If a testator cannot sign or make initials, what now? The Act makes provision for the making of a mark, which only applies in the case of a testator, not in the case of witnesses. And the Act also makes provision for someone else to sign on behalf of the testator. Question is, when do you use which alternative? Making a mark is appropriate for somebody who's illiterate and cannot sign or write his or her own name. And someone who cannot physically sign because the person is too ill or too weak, or a quadriplegic person or blind, should really get somebody to sign on his or her behalf. When the mark or the signature on behalf of the testator is used, the person signing on behalf of the testator, if someone signs on behalf of the testator, must comply with the following. The person must sign in the presence of the testator and must sign by the direction of the testator. In other words, there must be a moment where the testator says, please sign this document on my behalf. In the case of using a mark or someone signing on behalf of the testator, a commissioner of oaths must be present at the signing, and the commissioner of oaths must sign each page, and the commissioner of oaths must certify on the will the identity of the testator and the fact that the document is the testator's will. And that certification is in the schedule to the Wills Act. You will find an example of what such a certificate should look like. The full name of the Commissioner of Oaths, the full address, the capacity must be stated, and that the Commissioner has satisfied him or herself as to the identity of the testator, and that the document on which the certificate is effected is the will of that testator, and then the signature, the capacity, the place, and the date. Please note that nothing in the Justices of the Peace and Commissioners of Oaths Act of 1963 requires a stamp to be affixed when a Commissioner of Oaths certifies any document or signs any document or administers an oath. The Act requires those particulars that you saw on the certificate and nothing more. I have on occasion been on the receiving end of some clerk who insisted on a stamp. The Act does not actually require that. Any amendment of a will must comply with all formalities as required for a will. Amendments on the document opens the door for uncertainty and challenges. So good practice is, if any amendment has to be done on a will, it is much better to actually just redo the whole will. We live in the era where computers are widely used. The old typewriter is gone, so it is really not that much trouble to just redo the whole will and include and then effect the amendments that are required. any amendment on a will document is under section 2 sub 2 presumed to have been made after execution of the will, and it's obviously to safeguard against fraud. And any change to the document will not be valid unless signed by the testator and 2 witnesses. Because it is presumed to have been made after the testator and the witnesses originally signed the will, the amendment has to be signed separately by the testator and 2 witnesses. The 2 witnesses who sign at an amendment or next to an amendment in a will document do not need to be the same 2 witnesses that witnessed the original execution of the will. But as I said, just steer clear of this. It's not necessary. Just redo the whole will and get it signed again. So the question about codicils, does it make any sense to have a codicil done? And that's a good question. Let's look first at what is a codicil. According to dictionary.com, it's an additional supplement that explains, modifies, or revokes a will or part of one. My view is there is no point in doing codicils. Same reason as with amendments, rather redo the whole will. There's always the possibility, if the codicil is a separate document, there's always the possibility that it could be lost or that it could be separated from the will and that it could end up in a different physical location from where the will is kept, and then you sit with a problem that the codicil may not be given effect to. So over the last 50 years, with the advent of word processors and the use of computers, etc., the use of codicils has actually dropped sharply, and they are not used that often anymore. In fact, I cannot remember that I've seen a codicil in the last 20 years that was executed after 1985. Okay, so what happens if you do not comply with the formalities for executing a valid will? Under section 2 sub 3, the court has the power to condone, and if we look at that provision, it reads, if a court is satisfied that the document or the amendment of a document drafted or executed by a person who has died since the drafting or execution thereof was intended to be his will or an amendment of his will, the court shall order the master to accept that document or that document as amended for the purposes of the Administration of Estates Act 66 of 1965 as a will, although it does not comply with all the formalities for the execution or amendment of wills referred to in subsection 1. And the emphasis here, the bold words, that is my emphasis, is obviously not like that in the will itself, or sorry, in the act itself. So if we then look at what are the requirements, there must be a deceased person who has drafted or executed a document with the intention that that document must be his or her last will, and obviously that document must not comply with the formality requirements, because if it does, then there's no problem. This section is to save documents and give them validity where the formal requirements were not adhered to. So once the court is satisfied that these requirements are met, the court actually has no discretion. The Act says, the provisions of section 2 sub 3 read, as we have just read them, that the court shall order the master to accept the document as the will of the deceased. So the provision is peremptory. The court has the power and the duty to determine whether the document was drafted or executed by the deceased with the intention that the document must be his or her last will, and this document falls short of being a valid will because one of the formality requirements were not met. Okay, so let's look at a couple of cases. There was the early case of Becker versus Nordea in 2003. That was about 12 years after this provision was written into the Wills Act. In this case, in Becker versus Nordea, the deceased had a will drafted by a trust company on his instructions. I think it was ABSA Trust. The will was in his desk drawer for months without being executed. So he never signed it before he died. The court interpreted the word drafted in section 2 sub 3 as personally written or typed and not drafted by another party under instructions from the deceased. So in this case, in Becker versus Nordea, and the facts were such that there were indications that the deceased did not want to sign this document, that he was influenced by his spouse to have a will drafted. The will was drafted, but then it was lying in his desk drawer for months and he never signed it. So the court took that as an indication that he did not intend this document to be his will. In MacDonald versus the Master, a 2002 Free State High Court case, the deceased typed the will on his personal computer at his work. He wrote a note with instructions where to find it and the password to open it. He left the note on the pedestal next to his bed, on which his body was found after he committed suicide. He was lying on the bed, shot himself, and the court in this matter on application allowed a printout of the document retrieved from his computer in accordance with his instructions of where to find it and the password to open it. And the court then condoned this document as being his last will. In Van der Merwe versus the Master, A and B agreed to benefit each other in their wills. A executed the will properly. B never executed a will. He drafted a will in an email which he sent to A, and he died without properly executing the will. The court accepted a printout of the email as B's will on application by A, because of the fact that it was drafted by B himself and sent to the heirs, to A. What one has to remember of all these cases is that you have to bring an application to court. And a court will give its judgment based on the facts that are placed before the court. So in this case, in the Van der Merwe case, there was nobody opposing the application. This judgment has been criticized because in his previous will, B benefited some charities, which he did not do in this draft, which was contained in the email. And it has been proposed that the court should have given the charities a chance to say something about this. In Van Wetten and another versus Bosch and others, that's a 2003 Supreme Court of Appeals judgment. By the way, the Bosch was a previous national cricketer, fast bowler, Tertius Bosch. And he left a letter with instructions to a friend, and with it a will he drafted but never executed. So he never signed the will, no witnesses, but he drafted the document himself. And the court took the wording the deceased used in the document, as well as his instructions to his friend, into consideration, in deducing that it was his intention that this document was to be his last will. He described specific circumstances under which his friend should open the envelope with the document in it, etc. And when that happened, the friend opened and found the document, which the court then eventually condoned as his last will and testament. Smith versus Parsons, suicide note on a kitchen top in his house, in which the deceased indicated that his girlfriend must receive the house and some investments, but this note did not deal with all his assets. There were other assets that in his previous will were specifically dealt with, that was to go to his son. But the court regarded the fact that he put this note under his Bible with a crucifix on top as an indication of his intention that it should be his will. And the court then ordered that the two, his previous will and this note, must be reconciled, and that his estate should be administered in accordance with both of these documents. Then there was quite a shocking judgment in the Western Cape High Court in 2019, Dryden versus Harrison, where despite the fact that the deceased started his email to his girlfriend with the words, "This serves as my final will and testament," the court found that it was not sufficient indication of his intention that the email must serve as his will. The court's reasoning appears to be flawed, because there was no evidence that he intended to follow up this email with a formal document. So the court's reasoning was, this wasn't the will. He planned to make another will in which he was going to follow the same division of his assets as in this email, but he never got around to doing it. And therefore, he never intended this email to be his final will and testament. For the life of me, I can't understand, if somebody writes in an email, "This serves as my final will and testament," how it can be interpreted that it wasn't his intention that document should be his final will and testament. Then there was, in 2021, there was a case, Crossman versus the Master of the High Court, Johannesburg, and others. In this case, the deceased drafted a document and signed the second page of it in the presence of three others, including C. All three signed the second page as witnesses. So here, the deceased signed only the second page, not every page as is required by section 21A of the Wills Act. He bequeathed certain assets to C. C applied to the court to declare the document the deceased's last will and to declare her competent to inherit, because she signed as a witness. And therefore she would have been, as we'll see a little bit later, she would have been disqualified as an heir under section 4 A of the Wills Act. The court in this case held that it was clear from the evidence that the deceased intended the document to be his last will, and the court condoned the document under section 2.3. Remember, the document did not comply with the formalities because the testator only signed the second page and not every page as is required by the Act. And the court also then declared C competent to inherit. Now, much more. This was a Johannesburg High Court case, and then another shocker out of KwaZulu-Natal, Durban High Court matter. In this case, the deceased, Delport versus Leroux and others, and in this case, the deceased signed a will document drafted by his accountant. Accountant then took the document to 2 other persons to sign as witnesses, but they were not in each other's or in the testator's presence when they did so. So then D, the applicant Delport, brought an application to court to have the document declared the deceased's last will and testament. In the evidence, the accountant said that he drafted the will, that the will was signed by the deceased, in other words, executed by the deceased, and 1 witness. But the other witness wasn't there. So the accountant took the document to the other witness to sign it. And despite the fact that there was no evidence refuting the evidence of the accountant that the deceased actually signed the document, the court was unconvinced that he intended this document to be his will. And the court also found that he did not draft the document. So from this judgment, it appears that the court misinterpreted Section 2 sub 3. Because the section clearly says drafted or executed, and it appears as if the court regarded drafting and execution as the same action, which it is not. Drafting is physically creating the document, either writing it in longhand or typing it on a computer or creating it in some other way, and execution is the signing of the document by the testator. And the court basically regarded both as the same and said, no, well, it wasn't drafted by the deceased, and therefore there's no indication that it was his intention to that this document should be his last will and testament. So quite a shocking judgment. Why do we look at these cases? There are 2 very important points to note here. The one is that to have a will condoned under Section 2 sub 3 of the Wills Act, you have to go to court. You have to bring an application to court. That costs money. And it takes time, and therefore it's not a very satisfactory outcome. The second important point to note is it's a bit of a lottery. You don't know what the court is going to find. If somebody asked me to bet money on the outcome of the Delport versus Leroux matter before the court's judgment, I would have bet money on it that the document will be condoned based on the facts. And the court ruled otherwise. Now you can appeal, but then you have to go to Bloemfontein. And with apology to those people living there, I've lived in Bloemfontein in my life. It's in winter it's a cold, dreary place, and in summer it's a hot, dreary place. Now I loved staying in Bloemfontein years ago, but having to go to the Supreme Court of Appeals is quite an expensive exercise. I don't think you can take a case to the Supreme Court of Appeals where the total legal costs by the time you get judgment in the Supreme Court of Appeals will not exceed R1 million, and that then you will be lucky to get away with that. So you don't want to go to court, and therefore it is absolutely essential to make sure that you understand the formalities required for a valid will and follow them strictly if you have anything to do with wills. Danny, I see you are live.
Yeah, I want to. There's some questions that someone's asked. Someone was asking about the curatorship of the will, a person under the curatorship. If they,
Yes.
What's the reference for that, and possibly what would they do in that situation?
Yeah. Okay. I'll have to come back on the reference. I don't have it on the tips of my fingers. The thinking behind that is that people who are capable of looking after their own affairs are not placed under curatorship. So if you are placed under curatorship, there is a strong indication that you are not in a position to make sound decisions about your own affairs. And therefore, obviously, a minor who is not yet 18 years old, but is over 16 and is under curatorship because of minority. You may recall a couple of years ago we had the family murder in Stellenbosch, where the one child, the one son, was eventually convicted of having murdered his whole family with an axe, with the exception of his sister. That sister of his was placed under curatorship. A curator was appointed for her because she lost her parents and so on. So as soon as she's 16 years old, or she is older than that now, but as soon as she reached the age of 16, she would have been in a position to make a valid will, because there was nothing wrong with her mental faculty. But if you are placed under curatorship because you're not in a position to make sound decisions about your own affairs, then obviously you lack the capacity to make a will. You lack the mental capacity to make a will. But I'll get back to you on the authority for that.
And then there's another question that asks, what if a master loses the original will when submitted to him for the letter of executorship, now perhaps won't accept an affidavit from the surviving spouse or certified copy from a commissioner of oath?
Yes, the Administration of Estates Act makes provision. I'm not quite sure of the specific section, but the Act does make provision for the master to be in a position to accept a photocopy of the original will, if it can be shown that the original will is missing, and that the original will is not missing because the testator destroyed it with the intention of revoking. We'll get to revocation of wills in a minute, and one of the ways in which you can revoke a will is by destroying it, if you are the testator. If you're not the testator, it's a crime to destroy a will, but to willfully destroy the will. But if you are the testator, you can actually destroy the will with the intention to revoke it. There is a common law presumption about that.
Yeah, the person just reiterated that the master had lost the will. But,
yes, yeah. So if the master had lost the will, then a photocopy will suffice. There was a case probably 5 or 6 years, maybe even longer ago, in Gauteng about such a will. I forget the case, the parties, the names of the parties now, but I do recall that if the person wants it, just give us an indication. I'll dig it out and send it to you.
Perfect, thank you.
Okay. So the question, why a video recording on your smartphone cannot be a valid will in South Africa. Although the Wills Act does not define document anywhere, what you then have to do is you have to go to the dictionary meaning of a document, because the specific act does not define the word document, and as far as I know, there's also no definition of that in the Interpretation Act. So then you have to look at the dictionary meaning of document. But what is more, I mean, you can argue that these days we refer to a file on a computer as a document. Especially if you use MS Word, it even has the suffix doc or docx. But the Wills Act requires each page to be signed by the testator, and the witnesses are to sign in the presence of the testator and each other. And what's more, wills are specifically excluded from the Electronic Communications and Transactions Act of 2002, and therefore the only logical conclusion that one can arrive at is that a will has to be in writing and in a hard copy document that is capable of being signed. It cannot be an electronic document because it is specifically excluded from the provisions of the Electronic Communications and Transactions Act. There are only 4 documents that are excluded from the Electronic Communications and Transactions Act. That is a contract for the sale of land, which has to be in writing, under the provisions of the Alienation of Land Act, and a long-term lease of land, a bill of exchange, which we rarely use these days anymore. Bill of exchange obviously include a check, and South Africa abolished the use of checks some years ago. And then lastly, the 4th one is a will. So therefore, one has to the inescapable conclusion that one has to reach is that a will has to be in writing and a hard copy document. I've been asked over the last number of years, so why are we behind the curve on this? There are not that many countries in the world where electronic wills are just accepted as valid wills. The reason why, I think, is because other than a contract, different from a contract, by the time a dispute arises about a contract, the parties are usually still alive. So although documents, legal documents are interpreted on the basis of the document itself and not extraneous evidence, extraneous evidence can be adduced under certain circumstances, can be used under certain circumstances. But with a will, by the time a dispute arises, the testator is no longer with us, and therefore the potential for fraud is much more real than in the case of any other document where the parties are still alive. And therefore, very few countries accept electronic documents as wills without a court condemnation process, like the one we have. And as we've seen, our courts are quite willing to accept electronic documents under certain circumstances, once they comply with the requirements of Section 2, Sub 3 of the Wills Act. Okay, so the revocation of a will can be revoked in the following ways. By a revocation clause in a later validly executed will, by the testator physically destroying the document, which I referred to in our common law. If the testator physically destroyed the document and there is evidence that the testator in fact destroyed the document, or if the will was in the exclusive control the document itself was under the exclusive control of the testator and cannot be found after the testator's death, then there is a presumption that the document was destroyed with the intention to revoke it, that the will was destroyed with the intention to revoke it. It can also be revoked by the court declaring it revoked under Section 2, capital A of the Wills Act. When you do a revocation clause in a will, be careful. One has to be extremely careful with revocation clauses, especially these days with multi-jurisdictional assets or multi-jurisdictional estates rather, and multi-jurisdictional families where family members are scattered all over the globe and where the testator could have assets all over the globe. I earlier this year dealt with a matter where I was asked for an opinion where the deceased had two wills. One dealing only with the South African assets, one dealing only with his assets in another African country. But he also had assets in other countries with no will dealing with that. And both the wills specifically specified that it only deals with the assets in that country. So that becomes quite a complex situation, which you have to be very careful with, that you do not revoke wills that you do not want to revoke with careless drafting of a revocation clause in a will. The Wills Act does not require a will to be dated. There is no requirement in the Wills Act that there must be a date on a will, a date of signature or so. But it is very good practice to do this, to make sure that the will is dated, specifically for this reason. But you have to be very careful with the wording. What does the clause revoke? And let's have a look. There's a revocation clause that says, I, John Doe, married out of community of property with the inclusion of the accrual to Julia Doe, born Smith, hereinafter called my spouse, hereby revoke all previous wills, codicils, and other testamentary writings and declare this document to be my last will and testament. That clause will revoke all wills anywhere in the world. So that this clause makes it very clear that all previous wills, codicils, and other testamentary writings are revoked, and that this will is my last will and testament. Or you can have a clause that reads like this: I, John Doe, married out of community property with the inclusion of the accrual to Julia Doe, born Smith, hereinafter called my spouse, hereby revoke all previous wills, codicils, and other testamentary writings dealing with my South African estate, and declare this document to be my last will and testament with regard to my South African estate only. So this clearly only revokes then South African wills. You can also have a third possibility where you say, I hereby revoke all previous wills, codicils, and any other testamentary writings anywhere in the world except my South African will dealing with my South African estate. You can also do it that way around. But make sure that you understand what the testator wants to do and that the wording of the revocation clause actually achieves what the testator wanted to achieve. Okay, so under Section 2, capital A of the Wills Act, a court must declare a will revoked under Section 2A if the court is satisfied that the testator, with the intention to revoke, made or caused to be made a written indication on his will, or before his death performed or caused to be performed any other act with regard to his will which is apparent from the face of the will, or before his death drafted another document or caused such document to be drafted. So practically what it means is if you write cancelled on every page of the will document and draw diagonal lines across the pages, then that is a written indication on the will that you want to revoke. Drawing lines diagonally across the page without any writing will also be any other act. That will qualify with that second one. Any other act with regard to his will which is apparent from the face of the will, or drafting a new will which is not executed at time of death. Will that not? The accepted view is that drafting a new will which is not executed does not necessarily mean, if you look at the Becker versus Nordia judgment, does not necessarily mean that that will revoke the will. It is only if that document is condoned, that new will that was never executed is condoned by the court in an application under section 2.3, that such a new will which is not executed will revoke the previous will. And not always, it will not always revoke, as we've seen in the Smith versus Parsons case. All right, that takes us to, I think, after I've dealt with this, we should maybe take a 5-minute break. Wills and divorce, the provisions of section 2b. So let's have a look at what 2b says. Effect of divorce or annulment of marriage on a will. If any person dies within 3 months after his marriage was dissolved by a divorce or annulment by a competent court, and that person executed a will before the date of such dissolution, that will shall be implemented in the same manner as it would have been implemented if his previous spouse had died before the date of the dissolution concerned, unless it appears from the will that the testator intended to benefit his previous spouse, notwithstanding the dissolution of the marriage. So what does that mean? That means that you have 3 months after the date of divorce to change your will, to remove your ex-spouse from your will. During the 3 months, if you pass away, your ex-spouse will be deemed to have died before the date of divorce and will therefore not stand to inherit anything. After the 3 months, if the spouse, rather not the ex-spouse, if the spouse, the testator dies within the 3 months, after the 3 months, the ex-spouse now gets revived again, and will then inherit if the will bequeaths to my spouse. Now, interesting, if you have, and I've been asked this question and I don't have an answer because there is no case law on this, but where the testator married again and there is a bequest in the will after the expiry of the 3 months, any bequest to my spouse will mean my new spouse, and failing a new spouse, the bequest shall lapse. I think that's going to, if anybody writes anything like that into a will, it's going to result in quite an interesting situation. And I wouldn't want to hazard a guess what a court would say about this. It's very important to remind divorced clients to make a new will after divorce. You've got that 3 months. Make sure you do a new will. And to my mind, even if you still want to benefit your ex-spouse, do a new will in any event because your life has changed. You were married, you are now divorced, just do a new will. It's in any event a good idea to do a new will regularly. All right, so the latest case on this, First in the Western Cape High Court was J.W. versus Williams, Ashman, N.O. and others. And in this case, J and N were married for 5 years when N died on the 18th of December 2016. She executed a will 4 days before their marriage. In other words, in 2011, in which she bequeathed the full residue to my husband. The marriage ended in divorce on 24 October 2016. And because she died on the 8th of December 2016, it was within the 3 months, and her ex-spouse J could not inherit anything from the will saying, I bequeath the full residue to my husband. J attacked the Section 2B in court on the basis that it was contrary to Section 25 of the Constitution, that it took away his rights to legal redress under Section 34. The court rejected both arguments, as it said that the right of disposal over property is not absolute, and the section does not take away an ex-spouse's right to approach the court with evidence from the will that the deceased still intended to benefit him or her. J was not happy with that and went to the Supreme Court of Appeals. And this one is reported as 2023 judgment of the Supreme Court of Appeals, reported as W versus Williams, Ashman, N.O. and others. They dropped his initial. So in this case, J, or now W, urged the court to take extraneous evidence into consideration and argued that Section 2B deprived him of the right to inherit from his erstwhile spouse in conflict with her real intention, just because she died within the 3-month period after divorce as envisaged by Section 2B. W argued that the provision is arbitrary and with no rational basis. Supreme Court of Appeals would have none of this. The court, Judge David Unterhalter, acting Judge of Appeal, in a unanimous judgment of 5 judges, said that the provision has a rational purpose, as it can be assumed safely that divorcees do not want to benefit their ex-spouses. The fact that the deceased testatrix did not give any indication in the will that she wanted to benefit her divorced spouse is the only indication of a real intention that can be considered, and there's no reason to deviate from the settled legal principle that the will of a deceased is the ultimate expression of intention. So in this matter, Section 2B, the Supreme Court of Appeals also made short shrift of the argument that it's unconstitutional. Well, watch the space. W may still want to take this to the Constitutional Court on the constitutional grounds, but his appeal in Supreme Court of Appeals was dismissed with costs. So I think let's start. No, it may be a good idea to break here for 5 minutes. I see it is just on 5 minutes past 2, so let's resume at 10 past 2. All right, ladies and gentlemen, let's continue. We still have a lot to work through. What happens if an heir dies, is disqualified, or renounces a benefit? The heir dies before the testator, or the heir is disqualified or renounces the benefit. That is ruled now by, well, partially ruled by Section 2, capital C of the Wills Act. And let's have a look at what that section looks like. Section 2C says that surviving spouse and descendants of certain persons entitled to benefits in terms of will. 2C1 reads, if any descendants of a testator, excluding a minor or mentally ill descendant, who together with the surviving spouse of the testator is entitled to a benefit in terms of a will, renounces his right to receive such benefit shall vest in the surviving spouse. 2C2 reads, if a descendant of the testator, whether as a member of a class or otherwise, would have been entitled to a benefit in terms of the provisions of a will, had he been alive at the time of death of the testator, or had not been disqualified from inheriting, or had not after the testator's death renounced his right to receive such benefit, the descendants of that descendant shall, subject to the provisions of subsection 2, per stirpes be entitled to the benefit unless the context of the will otherwise indicates. So two important things to note with regard to these two provisions is firstly that this section only applies if the heir is a descendant of the testator. In other words, a child or a grandchild of the testator. That's the only circumstance under which Section 2 capital C will apply. The second is, and it's a very important point, is that with Section 2C sub 2, the provisions of this subsection can be written out of your will. You can have a contrary provision in your will. With Section 2C1, you cannot. You cannot have a contrary provision in your will with Section 2C1. Okay, so let's look at the practical implications of this. Section 2C1 is also only applicable to renunciation of a benefit under a will, not prior death or disqualification. It's only applicable to renunciation of a benefit under a will. It cannot be excluded, as I said. Does it mean that the descendant and the spouse must share the same benefit, or that both must just be entitled to any benefit under the will? Because, as we've seen, Section 2C1 says if any descendants, excluding a minor, together with the surviving spouse of the testator, is entitled to a benefit in terms of the will, renounces his right, such benefit shall vest in the surviving spouse. In other words, the question is, must the together with the surviving spouse, does that mean together just as heirs in the same will, or together share in the same benefit under the will, like, for instance, the residue of the estate, or the primary residence in which the testator and his family live? Or must they just be beneficiaries under the same will document? And that question we have no answer to, because we have had no court case dealing specifically with this. if one looks at the history of this provision and the Law Commission, the South African Law Commission's report, which led to this amendment being written into the Wills Act. The clear intention of this provision was that in situations where the surviving spouse does not inherit enough, the children can renounce their benefits and let those benefits, whatever benefits they are entitled to under the will, they can renounce that, and those benefits will then accrue to the surviving spouse. Now, as I said, we simply don't know, we don't have the answer to this question, whether they have to be joint beneficiaries in the same benefit, the same asset, or they must just be joint beneficiaries in the will. We don't know. Recently, in 2018, the Constitutional Court confirmed the judgment of the Western Cape High Court in Musa and others versus Haneker and others. The facts there were very briefly that the deceased was had two wives, and he was first married to the first wife under Muslim rights. It's a Muslim marriage. Then later, when he wanted to buy, he then later married this another woman, also under Muslim rights, as is allowable. And they then wanted to buy a house, and in order to qualify for a bond, he needed the second wife's income to be added or to be taken into account when the bank had to consider them for a bond. And in that process, the bank said, well, if you're not married to the woman, we cannot take her income into consideration in those days. It was in the 1980s. And then he then married, in a civil marriage, married the second wife. Then when he passed away, the children thought that they could renounce their benefits to look after both spouses, but then the registrar of deeds, the deeds office, refused to register the house in the name of both spouses because they did not regard the first spouse as a spouse. And the case then went to court. The Western Cape High Court said that the Deeds Act in that respect is unconstitutional, and the Constitutional Court confirmed this judgment, and Muslim marriages, or a spouse in a Muslim marriage, is also now regarded as a spouse for this provision, this Section 2. C1 of the Wills Act. Section 2C2, as I said, only applies to descendants, and it's applicable to the prior death of a descendant prior to the deceased testator, the renunciation of a benefit, or disqualification of such a descendant as an heir. The provisions, as I said, can be excluded from the will by expressing a different intention in the will. The as I said, is all the provisions are only applicable to descendants of the testator, and it means that the default option in all three cases is that the descendants of such a descendant will represent such a predeceased, disqualified, or renouncing descendant. But remember, I said that Section 2C only deals with descendants. It doesn't deal with all heirs. And therefore, in the case of other heirs, the jus accrescendi will apply. joinder. It's also known under the term joinder. But the jus accrescendi will apply. And what does that say? There are three joinders recognized in our common law. The one is joinder known as joinder re et verbis. The same under this one, the same asset is bequeathed to more than one person in the same clause in a will. In other words, I bequeath the residue of my estate to my brothers. If one of them cannot inherit, the benefit accrues to the others. So if one of my brothers is either disqualified or renounces or predeceases me, then, and I had three brothers, then that 1/3 will accrue 50-50 to my other two brothers. Joinder re tantum, the same asset is bequeathed to more than one person in different clauses of the will, and the effect is the same. If one of them cannot inherit, the benefit accrues to the others, to the other person or person. Yeah, it doesn't have to be a class like my brothers. It can be people mentioned by name, but they must not be descendants, because if they're descendants, then section 2C will apply. So section 2C amended the common law just with regard to descendants. And then the third form of joinder in common law is joinder verbis tantum. The same asset is bequeathed to more than one person in the same clause in specific proportions. If one of them cannot inherit, that portion goes to his or her intestate heirs. So if you say, I bequeath the residue of my estate to my brothers in equal shares, that is joinder verbis tantum. And then that means if one of them should predecease me, for example, then, and I had three brothers, then that 1/3 will not accrue to the other two brothers. It will accrue to his intestate heirs. So those are these three are the three forms of joinder in common law, and they, with regard to everybody other than descendants, they still apply. It is only with regard to descendants that section 2C will overrule the common law or amend the common law in that respect. All right. When drafting a will, you have to be careful to ensure that the testator understands what she or he wants to achieve with a shared bequest. And you have to ensure that the testator understands the consequences. That you can write the provisions of 2C2 out of the will. You can say, I bequeath to my 3 children, and should one of them predecease me, his or her share will accrue to the other 2 children. Because that is not what section 2C2 says, but you can write section 2C2 out of your will if you want to. 2C1 you cannot. Be careful with wording, because bequeathing to my brothers have different consequences from to my brothers in equal shares, because bequeathing to my brothers would be joinder re et verbis, and my brothers in equal shares will be joinder verbis tantum. So that is why you have to be extremely careful in drafting something like this. All right, let's look at the interpretation of provisions in wills. The golden rule of interpretation was settled in 1914 already in Robertson versus Robertson's Executors in 1914, what was then known as the Appellate Division of the High Court, but which is now the Supreme Court of Appeals. And in that case, the court said the golden rule for the interpretation of testaments is to ascertain the wishes of the testator from the language used. And when these wishes are ascertained, the court is bound to give effect to them unless we are prevented by some rule of law from doing so. So the court, the Supreme Court, then the Appellate Division, now the Supreme Court of Appeals in 1914 said, you look at the wishes of the testator as you ascertain them from the language used, and you cannot go outside this. Even a court cannot go outside. So how do you ascertain the intention of the testator? You also have to look at the full document, not only at the words used. You have to look at the context in which words are used, because in 2012, the Supreme Court of Appeals said in the Natal Joint Municipal Pension Fund versus Indemani Municipality, Supreme Court of Appeals said, proper approach to the interpretation of documents, namely that from the outset one considers the context and the language together with neither predominating the other. So you have to take into consideration the words used in a will, but you also have to take into consideration the context of the full document. Armchair evidence is always allowed. Armchair evidence is where the person who does the interpretation places himself in the armchair of the testator, so to speak, and you interpret with regard to the circumstances and the knowledge that the testator had, the circumstances within which the testator was when drafting the will. Now it's whenever there's a dispute, obviously this will go to court, but that is how the court will approach it. Extrinsic evidence, extraneous evidence, evidence from outside the document, extrinsic evidence, is only allowed in very limited circumstances, and I've made a list of that from the textbooks and so on. And it seems that the only three cases where the extraneous evidence can be used with regard to the contents of the will. There are other cases where you can use extraneous evidence about the validity of the execution. Obviously, you can then ask people, well, who signed first, and was everybody in the same room when the testator signed and the witnesses signed, etc., etc. But there are only three cases, it seems, where you can look at extrinsic evidence with regard to what is in the will, and that is the testator's intention with regard to collation. Now, collation is the rule that says that if the testator made donations to some of his heirs, those donations must be collated back into the estate at the time of administration of the estate. And it's usually excluded these days in a will, in a standard clause in a will that says I direct that collation should not apply. But if you do not exclude it, it will be included. The common law rule of collation will apply. And it looks as if with regard to collation, extrinsic evidence will be allowed. Evidence about esoteric words, in other words, words that are particular to a particular geographic location or a particular section of the population or a particular dialect. Evidence about the meaning of those words will be allowed. Extrinsic evidence from outside the document. And if wills have if words have apparently been left out of a will in error, then those evidence about those will also be allowed in limited circumstances. But generally, the document itself is the source from which you have to glean the intention of the testator. What did the testator intend to achieve with the provisions in the will? All right. Then we have Section 2, capital D of the Wills Act, which deals with the interpretation. And there are certain rules. I'm going to run through them here, not necessarily go to the text itself. If necessary, we can go to the text. But in short, Section 2D provides that adopted and has the effect that adopted children are regarded as the natural children of the adoptive parents. So in common law, natural parents and their natural children could inherit from each other even after adoption. Section 2D was written into the Wills Act in 1990. I think it took effect in 1992. And since then, adopted children are regarded as the children, the natural children of the adoptive parents. And all ties with the natural parents are broken. So after 1992, if a will refers to my children, it includes adopted children. And those adopted children cannot inherit unless they are specifically included in the will of their natural parents, and their natural parents cannot inherit from them unless they are specifically mentioned, a specific bequest is made to them. So the tie between natural parents and adopted children is cut, and the adopted children are regarded as the natural children of the adoptive parents, and they therefore inherit from their adoptive parents and not from their natural parents. 2D also says there are no more illegitimate children in our law of succession. When I was at university many years ago, you still had 3 categories of illegitimate children. Those conceived out of wedlock by unmarried persons, those conceived out of adulterous relationships, and those conceived in incestuous relationships. So you have different categories in common law. Section 2D says no child is illegitimate anymore in our law of succession. A benefit to children or to any class of persons will vest in all the members of that class who are alive at the time of death of the testator, or who are already conceived and born alive later. So the child that is already, or the grandchild, or whoever the class of persons may be, a class is just, I bequeath the residue of my estate to my children. That is a class. And it's not a closed class. Further members can be added to that. And by the way, that is a good way. It's a good way to bequeath to children, because of the fact that people do not regularly enough review their wills, and because of the fact that because they don't do that, then if you start naming children by name, you may exclude a child who was born after the will was signed. So my advice is always, if you want to bequeath to your children, usually you want to bequeath in equal shares. You don't even say equal shares, you just say I bequeath to my children. And if there are further children born, then they are automatically added to this class. And even if they are not born yet but have been conceived, they will be members of the class the moment they are born alive. Disqualification of heirs, unworthiness. In our common law, the most well-known rule is the bloedige hand neemt geen erf. And for those who do not understand any Afrikaans or Dutch, it's a Dutch maxim that comes from Roman Dutch law, which basically just means the bloody hand cannot inherit. So if you have killed the testator, you cannot inherit from the testator. But unworthiness to inherit is much wider than just killing the testator or the result of killing the testator. In our law, back in 1903, a person who influenced another into a life of immorality and substance abuse was ruled to be unworthy to inherit from the substance abuser when that person died. Also, in a marriage, in community of property, the spouse who caused the death of the other spouse was entitled to her half of the joint estate, but could not inherit anything from the other half. Case Daniels versus De Wet, and you have the references there. I was personally involved in the decision to take this case to court. Louise Daniels was the executor, and we were in the same business, but I was involved in the decision to take this case to court. And there it was a matter of Mrs. De Wet, who wanted to teach her husband a lesson. She arranged for somebody to rough him up a little bit, but the person took matters too far and shot Mr. De Wet something like 16 or 18 times. He died. And the question was, is Mrs. De Wet entitled to inherit from him? Because his will basically said that she would inherit certain things and some things would go to his children, and a testamentary trust was created for the children to place their inheritance in. And also the question was also whether Mrs. De Wet would be entitled to the proceeds of insurance policies on which she was the nominated beneficiary. The Cape High Court found in both cases no, she cannot inherit from him, because although she was not convicted of murder, she was convicted of conspiracy to commit assault with the intent to do grievous bodily harm. Although she was not convicted of murder of her husband, she was unworthy to inherit because of the circumstances in the case. And the court went further and said she can also not benefit from her own crime, and therefore she's also not entitled to the benefits under the insurance policies on which she was nominated as a beneficiary. Recently, in 2022, there was Smith versus Master of the High Court, Western Cape, and others. And in this matter, Mrs. Smith forged, the court found that she forged a document purporting to be the will of the deceased, and she was ruled unworthy to inherit before her murder trial commenced. A murder trial hasn't yet commenced. There was a newspaper report earlier this week in Die Burger, the newspaper here in the Western Cape, Afrikaans language newspaper, where the case was postponed again. The trial will probably start later this year. She's been charged with two other alleged co-conspirators with the murder of her husband, but she hasn't been convicted of anything. But the court in a civil matter found her unworthy to inherit and declared the document that she presented as a forgery, and found her to be involved in the forgery of the document and therefore unworthy to inherit. Now, there's also disqualification of heirs, statutory disqualification of heirs in section 4 sub A of the 4 capital A of the Wills Act. And let's have a look at what that says. It says any person who attests and signs a will as a witness, or who signs a will in the presence and by direction of the testator, or who writes out the will or any part thereof in his own handwriting, and the person who is the spouse of such a person at the time of the execution of the will, shall be disqualified from receiving any benefit from that will. And then there are further provisions which we'll deal with now and which we don't have to read verbatim. But the upshot is that if you sign a will as a witness or you sign on behalf of the testator, you and your spouse will be disqualified from inheriting. If you write any part of a will in your own hand, you will be disqualified from receiving any benefit, not only inheritance, any benefit under that will. And we'll see later what a benefit turns out to be. This will not apply if the court orders that the person may inherit, if the court is satisfied that the person did not defraud or unduly influence the testator. But again, then you have to go to court. And it will also not apply to a benefit that is not more than what the person would have inherited under intestate succession. And if the person who signed as a witness, then if two other witnesses apart from that person also signed the will as witnesses, in other words, there were 3 witnesses to the will, then section 4A will not apply. And here's the interesting one: being nominated as executor, trustee, or guardian in a will, guardian over the minor children of the testator, is regarded as receiving a benefit. And such a person, if that person signed as witness or signed on behalf of the testator or wrote any part of the will in his or her own hand, such a person will be disqualified from being executor, trustee, or guardian, or heir under that will. Let's quickly look at conditional bequests. There are 2 kinds of conditions. Suspensive conditions. An example of that is a suspensive condition suspends the bequest until the fulfillment of the condition. And an example would be, I bequeath 1 million rand to my son James, which amount will vest in him when he achieves his LLB degree. This is not a practical kind of bequest because the will, the estate cannot be finalized. The estate will have to be kept open until James achieves his LLB degree, and if he doesn't, the legacy will just fail, and that legacy will then fall into the residue of the estate. But even if so, it is very unpractical because you have to wait until the person achieves the degree. And also in this kind of bequest, there is no time limit. So James can take 20 years to get his LLB degree. And in the meantime, the estate has to be kept up, which is obviously not to be recommended. Then you have resolutive conditions. The bequest lapses when an uncertain future event happens. For example, I bequeath my house to my spouse until she remarries, which is also quite an impractical provision. I saw a will many years ago in which, after the testator, who was a farmer in the northeastern Free State, after he learned that people do not necessarily marry, they just live together, he thought up a convoluted scheme which was written into his will, in which he said that if his spouse inherits or his son inherits the farm, but subject to the lifelong usufruct of his spouse, or until she spends more than 5 consecutive nights under the roof of the farmhouse with another male person, which meant that her own grandchildren couldn't even spend more than 5 nights with her grandsons, couldn't even spend more than 5 nights with her in the house. The whole thing came to naught because she did marry, because there was no provision that said she couldn't marry. She did marry, and they stayed on the farm for 5 nights at a time, and then over the weekends they went and lived in her new husband's house in town, which wasn't very far away. So these things are usually not practical, and it underlines the old rule: do not try to rule from the grave. Now, what is a nude prohibition? The plural nuda praecepta, or the singular nudum praeceptum in Latin. If a conditional bequest is a nudum praeceptum, it is not valid. But let's first look at what are unlawful conditions. It's illegal conditions, for example, where the heir is required to do something illegal. Amoral conditions, for example, where a child is expected to divorce to qualify for the bequest, like I bequeath R1 million to my daughter Sue on condition that she divorces that good-for-nothing husband of hers. That is an amoral condition, and the bequest will usually be applied without the condition. And then conditions which are contrary to any provision of the Bill of Rights, and we'll get to that in a moment. And then the nude prohibitions, the nudum praeceptum. It is a resolutive condition without an alternative bequest if the condition arises. For instance, I bequeath the residue of my estate to my wife, to my spouse, until she remarries. Okay, and if she remarries, what happens? If there is no alternative for that resolutive condition, then it's a nude prohibition, and the condition is basically invalid and will not be applied. Okay, so let's look at freedom of testation and its limits. Now, South Africa has a very high level of freedom of testation. We don't have any forced heirship rules in many European legal systems, and incidentally in Mauritius. There are specific rules that dictate which part or how large a part of your estate you can freely bequeath. The forced heirship rules usually determine that the surviving spouse must get a specific portion of the estate, or a specific percentage of the estate. Children must get a specific percentage of the estate, and anything that is left can be freely bequeathed. That's your forced heirship rule. In our law, we don't have that. We have a very high level of freedom of testation. There are practical limits to freedom of testation. For instance, any provision that is contra bonus mores, that is against the good morals of society, teen die goeie sedes, as we say in Afrikaans. Those provisions are invalid, and the court will not give effect to them. There are constitutional limitations on public trusts, the case of BOE Trust Limited and another 2012 Supreme Court of Appeals case. This is another case in which I was personally involved in the decisions to take the matter to court. What happened is, after the Minister of Education versus Seifried's judgment in the early 2000s, in Minister for Education versus Seifried's, Dr. William Scarborough created a testamentary trust in his will in 1921 or 22, in which he created a trust for postgraduate study in engineering at the university, or at an overseas university after, for graduates of the University of Cape Town. But he limited that. He limited the benefits or the bursaries to bursars who were male, Gentile, and of European extraction. In other words, no females, no Jews, nobody not from European extraction. In Minister of Education versus Seifert, the Western Cape High Court ruled that unconstitutional, ruled that there's always been a limitation on freedom of testation in common law based on the boni mores, the good morals of society, and that these are now encapsulated in the Bill of Rights in the Constitution. After Minister of Education versus Seifert, we had the Emma Smith case, the Emma Smith Foundation case. I'm not going to go into the facts of that. In BOE Trust, in this matter, the testatrix created a trust for the study of organic chemistry at a European, UK, or United States university for students of one of the 4 universities which offered organic chemistry as part of their curriculum. And but she limited it to white students. And this will was drafted after the advent of the Constitution. And the us as trustees took the matter to court, to the Western Cape High Court. I was involved in the business BOE Trust there, and we took it to the Cape High Court and asked the Cape High Court to strike the word white in the light of the previous decisions of Minister of Education versus Seifert and the Emma Smith Foundation case. The Western Cape High Court refused because the Western Cape High Court said, although it's discriminatory, there is no indication that it's unfairly discriminatory because the motive of the testatrix was apparently to stop the brain drain from South Africa, because one of the conditions was that after studying overseas, that the bursar had to come back to South Africa. After the Western Cape High Court refused, we couldn't apply the provisions of the trust because the universities refused to participate because of the discriminatory nature of the trust provisions. We then took it to the Supreme Court of Appeals, and the Supreme Court of Appeals refused to strike the word white because it said that was what the testator wanted, and if it's impossible, there are alternative provisions, and so the alternatives must kick in if it's impossible to run that trust. Danny, I see, is there a question?
Yeah, there's a question asking about the maintenance of a surviving spouse act
Yes.
after the Rwanda case.
Yes.
The evolution of state, what is the effect, if any?
Obviously, in effect, the Maintenance of Surviving Spouses Act also limits your freedom of testation. Because, and I think I actually do say that later. Yeah.
Yes, okay.
Yeah. And obviously the accrual system, the Matrimonial Property Act, also, and then there's limitations on fideicomissa. You can only have 2 successive fideicommissarii after the fiduciary. And then obviously the Subdivision of Agricultural Land Act, and then effectively also the fact that your pension benefits are not part of your estate is also actually, practically speaking, a limitation of your freedom. Sorry, which case did the person refer to?
The Batwena, I think we just
Bwanya.
Bwanya.
Yes, I think I come to the Bwanya case soon. I just want to carry on with this, and then I think the Bonya case is actually on one of the next slides. The constitutional limitations on private wills, as the case of King versus the Jager, where the Jager, many years ago in the early 1800s or early 1900s, his wife and himself bequeathed all their farms to all their children. I think it was 4 sons and 2 daughters. And but after them, it was subject to fideicommission, and after their children, it would only go to their grandsons and great-grandsons. And this case was taken to court. The Western Cape High Court refused to intervene, said, no, we're not going to rewrite somebody's will for him. Supreme Court of Appeals also did that and did not even give a written judgment. They gave an extempore judgment where they said they can find no fault with the Western Cape judgment. The Constitutional Court then went into a long judgment. Well, there are actually, I think, 3 different judgments, but the majority ruled that it's unconstitutional and placed a limitation on that. Some lawyers are very up in arms about this. They regard it as an attack on human dignity, that you cannot deal with your property as you see fit. Then the other limitations we've basically spoken about already now, where you cannot really bequeath as you wish because there are limitations placed by these pieces of legislation. I'm trying to remember, where did I put Bonya in? I'll get back to it if I get to the end of wills. Pitfalls and practical considerations. Just make sure of wording. The words are all that is left after the testator's death, so make sure that wording is accurate. Cash or money, what does that mean? Does it include bank accounts? My business, what does that mean? Sole proprietorship, there's the case of Gradus and others with sports helicopters, and another 2012 case. I'm not going to go into this, but into the facts, but there was a helicopter crash, and some of the tourists sued the sole proprietor who operated these helicopter tours, and he then passed away. And the question was, can the estate be held accountable for the business liability of these claims for injury against the deceased? The court said no. That was a personal suit against him. He died. He's no longer here. He was a sole proprietor. There is no business against which you can sue. Partnerships, closed corporation or company, only interest or shares. What do you include? Buy and sell agreements, make sure that it is accurately worded, or make sure there are any, if not, what will happen. Registered in my name or in my possession, what does that mean? Personal effects, what does that include or exclude? Collections, coins, stamps, etc. A coin collection could be worth millions. Is that part of personal effects? So make sure, it's always wise to make sure what you include. Make sure that every word, that everybody understands what every word in that will means. The contents of my workshop, what is that? My garage, does that include the vintage Rolls Royce that happened to be parked in the garage? You see, that kind of thing can create a lot of uncertainty and disputes, and eventually court cases, which can become very expensive. Okay, so next we're going to look at the creation of trusts in a will. But first of all, I just want to run through this. Pitfalls and practical considerations. The different types of trust. Now, on this axis, on the left-hand side, I have the source of trust. Is it a testamentary trust, an inter vivos trust, or a court-ordered trust? And on this axis, I have whether it's an ownership or a bewind trust. Now, paragraph A of the definition of trust in the Trust Property Control Act refers, basically creates this thing which we know as an ownership trust, because it's the making over of assets to another person, the trustee, to own, hold, and administer for the benefit of the beneficiaries of that trust. And paragraph B creates what is known as a bewind trust, which is basically the assets are made over to the beneficiaries, but to be held and administered by the trustees on their behalf. So in an ownership trust, ownership rests in the trustees. In a bewind trust, ownership is held by the beneficiaries, but the assets are placed under control of the trustee. So in an ownership trust, you can have a discretionary or a vested trust. A discretionary trust is the trustees have discretion when and in what ratios and how much of the trust assets they want to distribute to the beneficiaries in accordance with the provisions of the trust instrument, the trust deed, whether it's a will or a trust deed, and so on. And all that I've done on this matrix is I've said a testamentary trust can be a discretionary ownership trust. It can be a vested ownership trust. Vested just means that you have beneficiaries in whom benefits have been vested from the beginning, whether it's just the capital that whenever the trust is terminated, the capital will be distributed to these beneficiaries, or whether it is that everything is vested in them from the beginning, but it's still owned by the trustee. But when it is distributed, it has to be distributed to those beneficiaries in those ratios. Yes, so a testamentary trust can be ownership discretionary, ownership vested, or it can be a bewind. An inter vivos trust, your typical family trust, can also be all three. You also get court-ordered trusts, and there it's unlikely that it will be a discretionary ownership trust. It is possible that it will be it can be a vested ownership trust, but most likely it will be a bewind trust. Okay, so why have I spoken about this? Because bequests in trust is the bequest to the heir or legatee if there is a testamentary trust created in a will. Is that testamentary trust a bewind or is it an ownership trust? And it will depend on the wording of the will. So if the bequest is to the heir or legatee, it will be a bewind. If it is to the trustees, it will be an ownership trust. And it makes a huge difference. Right, we've dealt with those points. So let's look at the wording of the bequest, because that is of the utmost importance to determine what type of trust is being created here. So if we say, I bequeath the residue of my estate to my trustee in trust for the benefit of my children. My trustee is empowered to receive and administer this bequest under the powers and duties more fully set out in clause XX below. This provision creates an ownership trust because the bequest is to the trustee, who will be the owner, but not for own benefit, for the benefit of the trustee. If the wording reads, I bequeath the residue of my estate to my children, to be kept in trust and administered by my trustee for the benefit of my children, my trustee is empowered, the rest of that clause. This provision creates a bewind, because ownership will now rest with the beneficiaries, the children. And that has implications, because once the children who are minors, once they reach the age of majority, they can then claim the benefits because it belongs to them. It's been placed under control of the trustees while they were minors. If you don't want that to happen, There is a way around this, but then it becomes complicated, because then you will have to say, if they do claim it when they get to the age of 18, if any beneficiary who claims it when reaching the age of 18 will forfeit the benefit, and that benefit will accrue to the other beneficiary. That's the only way you can avoid this. So it's of extreme importance to make sure that the trust, the bequest, which has to be held in trust, must be done in such a way that the right kind of trust is created. All right. What happens if you die without a will? I'm quickly going to finalize this, and then we can take another 5-minute break. If you die without a will, the rules of intestate succession will apply. Section 1 of the Intestate Succession Act 81 of 87. If there is a surviving spouse and no children, the surviving spouse gets everything. If there's a surviving spouse and children, the surviving spouse gets the hire of 250,000 Rand or a child's portion. Children get a child's portion each or equal share of what's left after 250,000 to the spouse. If there's more than one spouse, they share equally before the children. So they will either all get a child's portion, they all get counted as children for the calculation of the child's portion, or they will all get 250,000 Rand, and what's left will be divided equally between the children. If there's no spouse but children, then the children will share in equal shares. If there's no spouse and no children, then there's a 50-50 split to each parent, and if that parent's predeceased, then to the descendants of that parent. If there are no descendants of that parent, then along that line of the family tree to the nearest relative. Okay, so your division in intestate succession is done after the accrual claim is settled in an accrual marriage, and after division of the joint estate in an incommunicative property marriage. So you first settle the accrual claim, or in a joint estate in an incommunicative property marriage, you first do the division, and the rules will only apply to the deceased's half, not to the half belonging to the surviving spouse. So who qualifies as a spouse? And this is where Bwanya comes in. In Bwanya versus Master of the High Court Cape Town, the deceased and Miss Bwanya started dating, and then they sort of on and off moved in, she moved in on and off at his place, but she also stayed, some nights she stayed at the place where she worked as a housekeeper. And they were making plans to go to Zimbabwe for the deceased to meet her parents and her family and organize the lobola. And then the deceased died, and he died without a will. And she then claimed under the Intestate Succession Act to be treated as a spouse. She went to court. And she also then said that she should also be, in the alternative, she should be able to claim under the Maintenance of Surviving Spouses Act. The High Court in Cape Town found that Section 1 of the Intestate Succession Act and no, only Section 1 of the Intestate Succession Act is unconstitutional. And they couldn't find that with regard to the Maintenance of Surviving Spouses Act because of the judgment in Volks versus Robinson, 2005, I think, judgment of the Constitutional Court. She then went to the Constitutional Court for certification of the Cape High Court's judgment with regard to Section 1 of the Intestate Succession Act. But the point about the Maintenance of Surviving Spouses Act was raised again in the Constitutional Court, and the Constitutional Court ruled that in both the Intestate Succession Act and in the Maintenance of Surviving Spouses Act, a partner in a life partnership intended to be permanent should be regarded as a spouse, and it gave Parliament, I think, 18 months or 2 years to amend the acts. So Bwanya in the Constitutional Court basically reversed the decision in Volks versus Robinson, which said you choose your weapons, you decide whether you marry or not. If you're not married, then the Maintenance of Surviving Spouses Act. If you chose not to marry, the Maintenance of Surviving Spouses Act can't help you. All right, I think that's it as far as wills are concerned. If we have time at the end, I'll take further questions then. I think let's take a 5-minute break. It's 3:10. Let's be back at 1:15, and then we'll deal with the estates part of this presentation. All right, it's 1:15. Let us continue. I'm not going to spend time on this agenda. We've run through it in the beginning. So let's start with who can be an executor. At the moment, there is uncertainty in every other province except in the Western Cape whether Regulation 910 is still valid. This regulation was promulgated under Section 30 of the Attorneys, Notaries and Conveyances Admission Act 13 of 1934. It was promulgated in May 1968, and it was perpetuated by Sections 86 and 81 of the Attorneys Act in 1979 after the Attorneys Act repealed this old 1934 Act. It is not certain whether Section 119 of the Legal Practice Act 28 of 2014 is wide enough to save this regulation, whether it didn't expire when the Legal Practice Act repealed the Attorneys Act. Some of the master's offices sporadically demand compliance with Regulation 910. In the Western Cape, the Western High Court ruled that it still exists in the case of Koch versus Weiland, 2022 judgment. And the interesting thing is that this judgment, what happened here was that the applicant was appointed as an agent of the executor, Weiland. And they had an agreement about the administration of the estate and the sharing of the executor's fees. And at one stage, there was a dispute about the work that the agent did, and when the agent then sued for the under the contract, the case went to court, and the court ruled that Regulation 910 determines who may administer deceased estates, not who may be an executor. And the fact that Koch was an agent does not detract from the fact that he does not comply with Regulation 910 and therefore cannot or could not administer the estate, and therefore the court ruled against Koch. Now, in the judgment, the court does not really go into why Regulation Section 119 sub 2 of the Legal Practice Act perpetuates Regulation 910. The court glosses over it and sort of accepts that it still exists and that it was saved by Section 119 sub 2 of the Legal Practice Act. There's at the moment a case pending in Gauteng where Regulation 910 is attacked on constitutional grounds. The case has not yet gone to court. It's in the preliminary phases at the moment. The purpose of Regulation 910 was to regulate who, apart from attorneys, may administer deceased estates, because the regulation itself basically in paragraph 1 defines what trust companies and boards of executors are, and then in paragraph 2 states that only attorneys may administer deceased estates. And then in paragraph 3, it permanently exempts the following from the prohibition in paragraph 2, or the ruling in paragraph 2, that only attorneys may administer deceased estates. And it says that boards of executors and trust companies are permanently exempted from the provisions of paragraph 2. Public accountants registered under the old Act of 1951 are also permanently exempted. Now, the question is, is a chartered accountant exempted? And there is a strong view that chartered accountants are not exempt, because there was a break in legislation in the 1990s, and chartered accountants are not the successors to public accountants under the Act of 1951. In fact, auditors regulated by IRBA are the successors to public accountants under the old Act of 1951. So that's an interesting one. And then brokers licensed as such on 27 October 1967. Don't ask me what the significance of 27 October 1967 happens to be. But as you can see, that trust companies and boards of executors who were in business as such on that date are permanently exempt. And then paragraph 4 partially exempts natural persons nominated in the will. So if you are nominated by name as a natural person, as an individual in the will of a deceased person, then under section 14 of the Administration of Estates Act, the master has no option. The master, section 14 says the master shall appoint such a person as executor in the estate, unless the person is incapacitated and cannot be the executor, is incapacitated from being executor. Also, employees of attorneys, banks, and, would you believe it, employees of trade unions are also exempt. They can also administer deceased estates. Now, what the relevance of being an employee of a trade union with regard to the administration of estates is, I have no idea. Don't know. All right. So the further question then is, who can or should not be an executor? But before we come to that, just lastly on Regulation 910, the case that attacks this on constitutional grounds, which is pending in Gauteng, is the person bringing that matter to court argues that the Regulation 910 uses irrelevant criteria, and the provisions of Regulation 910 are not rationally connected to the apparent purpose of the provision, which is to protect the public. And the argument is that it uses irrelevant criteria because why on earth would employees of trade unions be exempt, but an individual which holds the advanced diploma in estate and trust administration from Free State University, but who is not a practicing attorney, is not allowed. Also, if you buy a trust company from its current owners, then your trust company can administer deceased estates, regardless of whether you have any knowledge or skills in that regard. So it will be interesting to see what comes out of that case. We should not be an executor. There are many arguments and counter arguments about family members as executors, but family members, one of the arguments for that is that the family members can shop around to find someone to appoint as agent for the best, or whether that means the lowest is a different matter, the best or lowest fee. Banks and attorneys are expensive. That's one of the arguments against using banks or attorneys. Trust companies drag out the administration to make more money. Yeah, by the way, banks and attorneys are expensive. Remember the executor's fee, the fee that the executor can charge is capped by legislation. It is capped at 3.5% of the gross value of the estate, and obviously there's VAT on top of that if the executor is registered for VAT. Trust companies drag out the administration to make more money. That's also not really true. Like whether you take 3 years or 6 months to, well, 6 months is almost impossible, but whether you take 3 weeks or 3 years or 6 months to administer a deceased estate, the fee stays the same, or the maximum fee stays the same. Another argument is you have to make sure that the nominated executor will still be around by the time you die, which may not be the case with a one-horse attorney firm, or a trust company may not even be around. So think about the longevity of whoever you nominate as executor. A good reason not to nominate a family member is the potential conflict of interest. And there, especially where the surviving spouse is not the natural parent of some or all of the children, think twice before nominating either the surviving spouse or some or all of the children as executors. You have to think very carefully about this. In this situation, it's also steer clear of nominating a child or two, as I said, and the matter that we referred to here, now it seems my link doesn't work. I will quickly go to the slide. I don't know why that link doesn't work. The case of Brimble, Hanneth versus Hanneth and others, 2021 Cape High Court case. The applicant in this matter is the surviving spouse, brought the application for the removal of the first E and second C respondents as executors in their late father's deceased estate. The practical administration of the estate was done by an employee of the third respondent, which was a trust company. Is claimed under the Maintenance of Surviving Spouses Act for 6 million plus. And despite requests by E and C, there was no substantiating information supplied as required by Section 3 of the Maintenance of Surviving Spouses Act. Under the deceased will, S receives a lifelong habitatio over the residence. In other words, she can stay there or rent it out for the rest of her life. The house where she lived with the deceased, the residence. The residue is bequeathed to the trust, to a trust. And E and C are also trustees and beneficiaries of that trust, and they are the nominated executor. E and C, in their capacity as trustees, then went and claimed 4 million from the estate for an alleged loan by the trust to the deceased to purchase the residence in question, the residence that in the will was made subject to the habitatio of the surviving spouse. S requested proof of existence of the loan, and ENC refused access to the trust's record. And the Western Cape High Court Judge Ashley Binns Ward expressed the court's displeasure that the matter was not resolved out of court, and he basically said ENC are hopelessly conflicted. They suffered from an irreparable conflict of interest, and he then went on to remove them as executors in the estate under Section 54(1)(a)(5) of the Administration of the Estates Act. So he didn't waste time to remove the two daughters as executors. And this raises the question, is it at all a good idea to nominate a family member? Because there will always be the potential of a potential conflict of interest, unless it is somebody that is too far removed to benefit or potentially benefit from the provisions of the will. Okay, so the process of administration of a deceased estate starts with the reporting of the estate, and Section 7 of the Administration of Estates Act says that the death must be reported within 14 days to the master in the area where the deceased resided. Prior to death, the report must be made by a family member, and the family members usually delegate this to the executor. So if the executor becomes involved very early in the process, then the executor will go and report the death in any event. Section 8 says that anyone holding a will of the deceased must hand it in at the master's office. So if you are, to refrain from handing in document which purports to be a will of the deceased is a crime under the Administration of Estates Act. Carries a maximum penalty of 7 years imprisonment. So hiding or destroying a will under Section 102 of the Administration of Estates Act can land you in serious trouble. The master must register every document received. So the master does not decide when the document is handed in at the master whether it's a valid will. The master must first register each document. And then afterwards, the master can decide whether it's a valid. The following minimum documents must be handed in. That's what the master's office require. I'm not sure all of them are required by the Act, and I'll deal with that in a minute. So there's a death notice form J294, which has to be handed in, original or certified copy of the death certificate, and that death certificate is the one issued by Home Affairs, not the death notice that is issued by the doctor to certify that the person has passed away. There must be an original or certified copy of the marriage certificate, if applicable, or acceptable proof of marriage. Now, one of the practical things that go awry these days is that when people get divorced, Home Affairs is not notified. Previously, up to some years ago, the clerk of the court, where the divorce order was issued, informed Home Affairs and sent the documents to Home Affairs, and Home Affairs then changed their records. That has stopped for some other reason, which I couldn't figure out. Nobody seems to know why it was stopped. And now it is the divorcee's job to notify Home Affairs that he or she is divorced. And what now happens is, when you report an estate, the master checks with Home Affairs, and if the marital status that you report as an executor or a family member differs from what the Home Affairs records reflect, then the master refuses to issue letters of executorship. I'm fairly convinced the master has no right to do so, because at the stage of issuing the letters of executorship, the marital status is totally irrelevant. It becomes relevant upon the drafting of the liquidation and distribution account. And there's a very good reason why you want the letters of executorship as soon as possible, because you have to, as executor, take charge of the estate assets and make sure that the estate assets are safeguarded. There must be a declaration of marriage by the surviving spouse indicating the marital regime. All original wills and codicils or documents purporting to be such must be handed in. The completed inventory, form J243, showing all the assets of the deceased. Completed acceptance of trust as executor, form J190. Certified copy of the photo page of the executor's ID document. All documents that you have to fill in as an executor are available at that link on the master's website. Inventory must be supplied to the master by the surviving spouse or nearest family member under Section 9, but again, it is usually the executor that does that on behalf of the family. The inventory must contain all the known assets at the time. The inventory must include assets of the deceased if married out of communitive property, and if married in communitive property, then the assets of the joint estate. Because remember, in a marriage in communitive property, it is the whole joint estate that is administered. Although half of everything belongs to the surviving spouse, it is a half undivided share of each asset. So certain assets cannot be released to the surviving spouse because it belongs to him or her. Surviving spouse owns an undivided half share in every asset, unless that asset is excluded from the community of property for some reason. Details of the person present when the inventory was made must be supplied to the master. So, the executor can be nominated in the will, but only the master can appoint an executor, and the master does so under section 14. And as I said earlier, as long as the nominated executor is not incapacitated, the master shall appoint the nominated executor if the nominated executor is a natural person. And I have no doubt that under paragraph 4 of Regulation 910, a natural person was exempted from the provision that only attorneys may administer estates, exactly because of this provision in the Estates Act, because a regulation cannot amend an act. I have no doubt that paragraph 4 includes a natural person nominated in a will because of the provisions of section 14, because the nominated executor, if a natural person and not incapacitated, the master has no choice. The Act says the master shall appoint that person as the executor in the estate. Appointment is by issuing of letters of executorship. I think it's section 13 that says nobody shall administer an estate except under letters of executorship, and except your so-called section 18.3 estates, where the value is under the value determined by the Minister of Justice, which at the moment is 250,000 rand. Incidentally, if the original, if the amount, which is now 250,000, had been inflation indexed from the time when this was first brought into the Act in the 1980s, mid-1980s, 1985 or 6, around about there, that amount should be close to 1 million now, not 250,000. So anything under 1 million should be regarded as, or the equivalent of anything under 1 million was regarded as a small estate back in 1985-86 when this provision first became effective, section 18.3. The master may require security. The master may even require security even if the will directs the master to dispense with security. So the master may still demand security even though the will directs the master to dispense with security. Yeah, as I said, under section 13, only with letters of executorship you can start the administration of the deceased estate. That has become a huge problem because of delays in the master's offices and backlogs and so on, which existed prior to COVID, was exacerbated by COVID and hasn't really recovered. In some master's offices, service levels are quite acceptable. Notable examples are Bloemfontein and Kimberley, and to an extent Port Elizabeth is also not that bad. But in some master's offices, it's really a lottery how long you're going to wait for letters of executorship. There are developments afoot at the moment to use IT systems much more effectively, and some pilot project was tested in the Johannesburg Master's Office and in KwaZulu-Natal with regard to the electronic issuing of letters of executorship with a QR code to prevent fraud and forgery and so on, which from time to time rears its head, and criminal syndicates are not running around with duplicate letters of executorship are not unknown. So watch this space. Hopefully there will be some developments in this in the next year to speed up the process, make more use of IT, and prevent fraud and forgery. The executor must take control of all assets under Section 26 once in receipt of the letters of executorship. One of the problems with the delays is that you cannot, the banks don't even want to talk to the executor before the executor has the letters of executorship. And that results in a situation where money could be withdrawn from bank accounts because the bank doesn't know that the person is dead. The executor is placed in an invidious position because struggling to get letters of executorship can cause problems with the executor's duty to take control of all assets under Section 26. The executor may leave assets under the control of a person who claims to have a right to retain control under a contract, a retention, or an attachment, but obviously the executor will have to make sure that that person actually has the right. The executor may release funds for subsistence of the deceased's household. I always hear the advice, which I don't regard as good advice, that all life policies should have nominated beneficiaries, and none of that money should end up in the deceased estate, because then the surviving spouse has something to live off, and you save executors' fees and all that. The flip side of that is that a cash shortfall in a deceased estate is the biggest single cause of delays and friction in the administration once the executor has his letters of executorship. Well, maybe not the biggest single, maybe in some master's offices, the master's office service levels may be a bigger cause of delays. But it's not a good idea to leave a deceased estate entirely without cash. The executor can obtain a search warrant on suspicion that someone is hiding estate assets. The search warrant must be executed as if looking for stolen property. The person executing the search warrant must hand any property of the deceased found during the search to the executor, because the executor is charged under Section 26 with the control of all assets of the deceased estate. Now, under Section 29, the executor must place an advertisement in the Government Gazette and a newspaper circulating in the area where the deceased lived. The advertisement must invite creditors to lodge claims against the estate. The period must be at least 30 days from placement of the advertisement, and the Act prescribes the information that must be in the advertisement. It's usually the name, the address of the executor, the date by which debtors and creditors must contact the executor, etc. The Act does not actually require that the advertisements in the Government Gazette and in the newspaper must be on the same day. And we realized that a number of years ago. In the center of the country, in the Free State, Northern Cape, etc., the only daily newspaper that was still in circulation is the Volksblad, the Afrikaans newspaper in Bloemfontein. And the Volksblad, their distribution, the Volksblad actually went completely digital and electronic. There is no paper newspaper distributed. The Volksblad is not printed anymore. It went electronic completely. And Netwerk 24, the media arm of Naspers, then basically moved the small ads to the community newspaper that appear once a week or once in 2 weeks. And when we then looked at the Administration of Estates Act carefully, we saw that the Act does not require the advertisements to be on the same day. It just says it must be both, and there must be 30 days for debtors and creditors to respond. And therefore, the Chief Master's Office then issued a directive that said that the 30 days will run from the date of the last advertisement. I know there are moves afoot to rewrite or substantially amend the Administration of Estates Act, and that will have to take into consideration that print newspapers are dying, and electronic media is taking over. So yeah, you'll have to watch the space and see what happens when a draft bill does come out. There is currently a draft bill amending certain sections of the Administration of Estates Act, but those are just to deal with the things like the fact that Section 28 still requires or still refers to checks, and we don't have checks anymore, and so on. That bill hasn't even been published for comment because the Minister of Justice is of the view that it is not necessary to publish it for comment because all the amendments are necessitated by developments in the modern world, in the times we live in. The claims for and against the estate, property in an estate may not be sold in execution before the expiry of the period to lodge claims. After the expiry, it may not be sold in execution without the consent of the master or the court. This was at some stage taken to mean that a creditor cannot sue for an unpaid debt. And that until a number of years ago, the case of, if I remember correctly, Nedbank versus Steyn, in which the High Court, in which the Supreme Court of Appeals actually ruled that a secured creditor like a bank holding a mortgage over a fixed property can actually get a judgment and execute a judgment by attaching a fixed property. The executor must receive all claims against the estate and accept or reject each one. The executor must collect all claims in favor of the estate. You cannot decide not to collect some of the claims, like, for instance, an accrual claim in favor of the estate. What the executor can do is apply set-off and say, well, the surviving spouse is in any event going to inherit this, so I'm not going to collect the claim, but the executor must show that claim in the liquidation and distribution account as the accrual claim in favor of an estate must show it in the liquidation and distribution account as a claim in favor of the estate. The executor under Section 28 must open a current bank account as soon as he or she holds more than R1,000 of estate funds, and may open a savings or an investment account. And this is the section that still refers to checks, which is now bound to be changed soon. The executor may convene a hearing before the master or a magistrate to obtain evidence about disputed claims under Section 32. After the advertisement period, after creditors lodge their claims and the executor is happy that he knows about all the claims in favor of the estate, the executor must determine the solvency of the estate under Section 34. If the estate is insolvent, the executor must notify all creditors owed more than R1,000 and request the creditors within a period not less than 14 days to indicate whether they wish the estate to be handed over to be dealt with under the Insolvency Act 24 of 36, or whether the executor should carry on under the Administration of Estates Act. If the creditors fail to exercise this option, If they say, no, it's okay, carry on under the Administration of Estates Act, the executor carries on. The executor will then liquidate all the assets. In other words, sell all the assets, pay all the creditors, take the executor's fee and distribute anything left amongst the heirs and legatees. Okay, in a solvent estate, the executor must submit an L&D account to the master within 6 months after receiving letters of executorship. The master may extend this time, and usually in complex estates, the time is extended when it is virtually impossible to do an L&D account within 6 months after receiving the letters of executorship. The format of the liquidation and distribution account is prescribed in the regulations published in 1972 under Section 103 of the Act. And the L&D, the liquidation and distribution account, can be a first and final account, or there can be more than one account. When assets are found after the account was submitted, a supplementary account or accounts can be lodged or submitted. The most that I have seen in a deceased estate is about, if I remember correctly, there were 9 liquidation and distribution accounts in an estate where I was approached for an opinion on the estate duty liability some years ago, 5 odd years ago. The liquidation and distribution account must include the following: a heading, number, and in the heading must be the number of the account. In other words, is it the first account or is it a further account? Full names, date of birth, ID number, marital status, and marital regime of the deceased, whether amassed estate or not, and the master's reference number. There must be a money column showing everything coming in and going out. There must be a subheading liquidation account. In the liquidation account, all the assets are shown. Liquidation does not mean selling everything in this instance in a solvent estate. It means putting a value on everything, listing everything and placing a value on each asset. A subheading, a recapitulation statement. A subheading distribution account. Recapitulation statement is just a counting back of everything to make sure everything is there. A subheading is the subheading distribution account. In the distribution part of the account, the executor shows what is done with each asset. In other words, it's awarded to heir A, or it was sold, and the cash put in the cash. The recapitulation statement is basically all the cash. A subheading income and expenditure account. A subheading fiduciary assets account, that's usufructs, fideicomissa, habitatios, usus, and so on. A subheading estate duty addendum, which is different from the Rev 267, the estate duty return that the executor must lodge with SARS. And there's a certificate by the executor saying that everything is here and everything is properly valued and so on. The L&D account must be advertised under Section 35(5). The master must examine the account and may request vouchers in support of the account. Once the master is satisfied, the account must lie open for inspection at the master and the magistrate's office for 21 days, and the executor must again advertise in a newspaper and the government gazette that the account is open for inspection. And again, the 21 days will run from the date of the last of these 2 advertisements. If they're on the same day, good and fine. If they're not, the 21 days runs from the last date. Any interested party can submit an objection to the master under Section 357. And if free of objections, the executor can distribute in accordance with the L&D account and take the fee. The a misapprehension has developed in the industry and in the master's offices that the master must approve the account. That's not quite true. The master has no authority to approve or refuse to approve an account. The master may request vouchers in support of the account, and if the master is satisfied that the account properly reflects, then the account must lie open and the executor must advertise. And after the 21 days, the master does not approve the account. The master informs the executor whether there were objections, yes or no. If no objections, the master has no further role to play, and the executor can distribute and take his fee. If there are objections against the account, the master must refer it to the executor, who must respond within 14 days. The master must consider the objection and the executor's response and reject the objection. So here the master plays a role. The master has a what is known in law as a quasi-judicial function here. The master must consider the objection and the response by the executor and reject the objection or instruct the executor to change the L&D account to make provision or to address the issues raised in the objection that was allowed by the master. And then after this, anyone dissatisfied with the master's decision may approach the court with an application to set the decision aside. And if the objection is rejected by the master, obviously the executor distributes the estate. Obviously, if the person whose objection is rejected has all the legal remedies still available to him or her and can approach the court for an interdict to say, don't distribute, I am taking the master's decision on review, and the court will grant an interdict or not, based on whether the court is of the view that there will be irreparable harm if the if the interdict is not granted. The executor's fee is just another claim against the estate, and it should not be taken before the account is free from objections and all other creditors are paid. I think it's not only illegal, it's also unethical to take the fee before the estate is ready to be distributed. Fee is regulated to a maximum of 3.5% of the gross estate value, which I said before, and that 3.5 is obviously subject to VAT if the executor is registered for that. Then it comes to 4.025%, if I remember correctly. Professional fees for property valuations, transfer costs, immovable property, or income tax and other compliance services are claims against the estate. Executor is entitled to other general administration costs as allowed for in master's directives, postages and petties and things like that. Executor is also entitled to an income collection fee of 6% of all income collected. So if the income is 1,000 Rand, then the executor is entitled to 60 Rand. The income collected is 1,000 Rand, then the executor is entitled to 60 Rand. If it's 100 Rand, then it's 6 Rand. Obviously, 6% of the collected income. Income tax. The deceased is liable for income tax from the beginning of the tax year to the date of death. The shortest such tax year that I'm aware of is a good friend of mine died on the evening of the 1st of March, which is the end of the first day of the new tax year. But there is a pro rata tax year from the beginning of the tax year to the date of death. In other words, 1 March to whenever the date of death of the deceased. The deceased estate is a separate taxpayer. So from the date of death to the end of that first tax year in which the estate is under administration, that's a second tax return in the name of the deceased estate, which has to be submitted to SARS. Liable for income tax and including CGT, from the date of death until the date of distribution of the asset. So there are the deceased estate itself can pay capital gains tax if there's a disposal other than awarding to an heir, and there was an increase in value from date of death to the date of disposal of that asset. So if an asset is sold out of the estate and there was an increase in value from date of death value to sale value, then obviously there could be a capital gains tax liability. As a separate taxpayer, the deceased estate has its own 40,000 annual exclusion from capital gains tax. But for every year that the administration continues, the executor has to lodge a tax return for the estate. The executor is the representative taxpayer for both the deceased's last income tax return as well as for the estate's tax return. Cost of compliance with the Income Tax Act is a claim against the estate. It's advisable for the executor to obtain specialist services for this if appropriate. I mean, don't try to do it yourself if you don't know what you're doing. Paying all creditors, including service providers, to the estate, tax liabilities, etc., are all part of the distribution of the estate. Giving instructions for the transfer of immovable property, transferring of investments like listed shares, collective investment scheme units, and the like to legatees and heirs, selling assets to generate cash if necessary, paying out cash, all of that part of the distribution of the estate. Now, estate duty under sections 11 and 12 of the Estate Duty Act 1955, the executor is also the representative taxpayer for the payment of estate duty. And this duty may be recovered from certain parties. The executor can recover the duty from the beneficiaries under insurance policies under section 11. So the executor must pay from the estate, from the residue of the estate, but can recover, can collect estate duty caused by insurance policy. But bear in mind that the way sections 11, 12, and 13 are written, are worded, those policies, or the persons who receives the proceeds of those policies, get a pro rata share of the 3.5 million standard abatement. And therefore, you can have a situation where the only reason why there is estate duty payable is because of an insurance policy which pushes the estate beyond the net value of the estate beyond the 3.5 million. And because of that, the residue may have to pay a pro rata portion of that estate duty, which wouldn't have existed hadn't it been for that, for the insurance policy. So just be aware of that. To say the executor can recover doesn't solve all the issues around that. Formula for calculating the duty to be recovered is applied in section 13, and if the duty is not paid within 12 months from date of death, interest at 6% per annum will be charged on the outstanding amount. And please bear in mind that the commissioner has no authority to waive the interest. That was pointed out to me by SARS some time ago, but the commissioner actually has no authority to waive interest. The because the interest is put in created by Section 10. The Commissioner has an authority under Section 10 to delay the date beyond the 12 months if the Commissioner is satisfied that the delay wasn't caused by the Executor or any beneficiary under the estate. Yeah. Another person liable for duty under Section 10. All right, that's everything for now. I see there is something in the question and answer box.
Okay,
yeah,
thanks, Louis.
Interesting questions.
Yeah,
Yes.
carry on with the questions, fine.
So I have a question. Is there still a reason to be married after the Bwanya case ruling? We will have to see what the legislature does with regard to Section 1 of the Intestate Succession Act. At the moment, the courts have basically developed tests to determine whether a life partnership is intended to be permanent. Because otherwise, you can just rock up and say, well, I was in a permanent life relationship, and therefore I qualify. So we'll have to see what the legislation looks like. But at the moment, the courts look at things like, was there did the two parties contribute? Both contributed to the household expenses. Did the two parties live under the same roof? Did they live as husband and wife? And we've had this in the tax legislation for quite some time now, probably for more than 20 years, since it came into the Estate Duty Act and into the Income Tax Act the first time. Yeah, there's the one thing that I would always advise people to do is to, if you don't want to get married and you want to live together in a long-term relationship, then at least enter into an agreement, a relationship agreement. If you do not, one of the parties are going to come short when that relationship is terminated. Then the question is, if you want to take the trouble of entering into an agreement, getting married confers certain rights on you in any event. So if you are going to go to that amount of trouble, then what is the problem with getting married? So it's an open question. Second question is, can you state in your will that a bequest to your adult child must not be split with the adult child's spouse, even if they're married in community property? Yes, you can, but that provision in a will is only enforceable against the child's spouse. It is not enforceable against third party. So in other words, a creditor of your child's spouse, if the joint estate is sequestrated, is declared insolvent, then that protection is not effective against the creditors of your child's spouse. So to my mind, the best advice is your child should not get married in community of property, and that's the safest way to make sure that your child spouse's creditors cannot get hold of the inheritance. Yes, there's a remark that the more and more South Africans are holding foreign assets. Effect of this trend holds implications for wills and the administration of the resulting estates. Yes, absolutely. As I mentioned, I wrote an opinion for a client in a deceased estate earlier this year about assets in 2 African countries and in Europe, and it can become quite complex. So that's a matter for estate planning. It's too late when it's a deceased estate to start worrying about it. You should worry about that during the estate planning process. Next question is, deceased lived in SA for the last 35 years, born in the UK, has a house in SA, has a UK bank account. Is this bank account excluded from estate as non-resident? I take it as a UK bank account. I take it the question is about estate duty. If it's about estate duty, then the answer is, if the bank account was acquired after he became a South African resident, it will fall into the estate for estate duty purposes, into the South African estate for estate duty purposes. Obviously, any inheritance tax paid in the UK will count as a credit, because we have a double taxation agreement with the UK dealing with that. If it's about whether the South African executor will deal with it, that will depend on the conflict of laws rules in both countries. If the general rule in South African law, South African international private law, is that movable assets are dealt with under the lex domicilii, the law of the country in which the person was resident when he died, and immovable assets like fixed property, a house or something like that, is called situs assets. It's ruled by the lex situs, the law of the country in which the asset is situated. Next question is, if the executor removes money from the estate account and keeps it for himself without justification to the beneficiaries and without finishing the winding up of the estate, what should the beneficiaries do? Under normal circumstances, I would have said go to the police. I'm not sure that's going to help. But you should take legal action, and you should report it to the master. And if the local master doesn't do anything about it, then escalate it to the office of the chief master in Pretoria. Because, I mean, that is basically theft. Looks like I'm still online. Load shedding just kicked in here, but I do have a backup system. So let's quickly look at the next one. Please remember to furnish reference or authority review person under curatorship not competent to execute a will. Okay, I will dig up that and send it to Danny. Is a joint will treated differently to normal single wills? Obviously, both parties are also beneficiaries of the will. Is this a problem? Look, as far as I'm concerned, if it's a joint will, but the parties are married out of community of property and they just made a joint will, which I would never recommend. Then and they each deal with their own assets. It's just in a joint document. Then it's a normal single will. One of the reasons why I am usually against joint wills is because if the survivor does not make a new will, that will is still the last valid will, that joint will. and that joint will then be in the master's office. And good luck to try and get a copy of that in certain master's office. I always advise against joint wills unless there is massing, when you have to have a joint will. But massing is also something, unless it's a marriage in community property, massing, to my mind, you should also think carefully whether there aren't any other ways to plan your way out of the situation where massing is necessary. Okay, Danny, it looks like those are all the questions in the question and answer. I see there's one in the chat box. I don't know whether...
Yeah, I just wanted to know if you can answer that question.
Have I answered it? Okay, cool. All right. We're 15 minutes over time, but it was a lot to cover.
Yes, and he actually did it masterfully, and it was very in detail, and I'm sure everybody came away a lot wiser about the situation. So I really want to thank you for your time and for the effort put into this, and thank everybody for your attention. It was riveting, and your certificates will be on the way in the next day or two. And next month we have seminars coming up. As Danny says, if there's anybody that has any topics that you would like us to add, please let us know. I see there was one suggestion about administration of estates. And so once again, thank you and have a good evening.
Thank you. It was a pleasure doing it. Thanks.
Thank you, Louis.
Thanks. We're closing off.